This week in U.S. immigration news, we are going to cover EAD solution for E and L non-immigrant spouses. U.S. has taken in 690 Ukrainian refugees. U.S. lawyers volunteer to help Ukrainians. Judge blocks DHS memo. Title 42, unsafe conditions in detention centers. Remain in Mexico policy continues. Cameroonians want TPS designation. USCIS announced it has updated guidance in its policy manual to address the documentation that certain E and L non-immigrant spouses may use as evidence of employment authorization based on their non-immigrant status. On November 12, 2021, USCIS issued a policy announcement to clarify that the agency will consider E and L spouses to be employment authorized based on their valid E or L non-immigrant status. DHS added new class of admission codes to distinguish between E and L spouses and children. An E or L spouse age 21 or over who has an unexpired Form I-94 that USCIS issued before January 30, 2022, will be sent a notice. The notice, along with an unexpired Form I-94, will serve as evidence of employment authorization. Russian attacks in Ukraine have displaced 10 million people inside the country and as refugees abroad. Latest UN data shows about 3.4 million Ukrainians left their country. Poland has welcomed about 2 million people. Another 1.4 million Ukrainians have fled to Romania, Hungary, Slovakia, and Moldova. Roughly 185,000 refugees have fled in the opposite direction to Russia. The US has so far taken in a low number of Ukrainian refugees. Biden administration earlier this month granted temporary protected status to Ukrainians already in the United States. There is a group of lawyers signed up to volunteer to help Ukrainians apply for this benefit and advise them on other immigration relief that may be available. The volunteer project will be ready to help but is waiting for the Biden administration to take formal steps to grant Ukrainians TPS designation for 18 months. Contact Ting Law Group to receive this information. A federal judge in Ohio partially blocked the Biden administration's mandate to ICE officers to prioritize deporting serious criminals and to weigh the totality of circumstances before deportation. DHS sent a memo in September 2021 that encouraged ICE officers to weigh factors such as community and family ties, age, time spent in the U.S. and mental health before making an arrest. The memo was challenged by Arizona, Montana, and Ohio. Judge Michael Newman from Ohio limited the scope of the memo by stating that such directives must come from Congress, not the executive. This decision blocks the part of the memo that relates to those facing mandatory detention due to a criminal record.
If you are new to our channel, welcome and please subscribe to stay in the loop. We offer free 15-minute consultations if your case is qualified so we can point you in the right direction. Stay tuned for the secret code later in the show.
With the 2-year anniversary of Title 42, the Biden administration has barely shown any indication of intending to lift the pandemic health policy that expels asylum seekers. The continuation of Title 42 has caused tension between the Biden administration and immigrant communities, many of whom see the continued use of the rule as a broken campaign promise. Some immigration advocates claim Title 42 is used to leverage the pandemic to implement hard restrictions on asylum seekers. Both the Biden and Trump administrations have claimed Title 42 is necessary to prevent the spread of the coronavirus. A report was released on Friday that showed the unsafe and unsanitary conditions of a privately owned and operated jail in New Mexico that is used to hold migrants. The DHS Inspector General recommended that everyone at this facility be immediately transferred elsewhere based on the findings of an unannounced inspection in February. The facility is owned and operated by a private company called CoreCivic. Both ICE and CoreCivic dispute the allegations of the egregious conditions. CoreCivic receives about $2 million per month from the government to operate this facility. At the time of the inspection, there were 176 men held there. According to DHS, the Biden administration has placed over 1,500 migrants from several Latin American countries in the controversial Remain in Mexico program. Compared to January, the number of migrants in the program has doubled during February. No citizens from outside Latin America, and only one from the Northern Triangle of Central America, are enrolled in Remain in Mexico, formerly called Migrant Protection Protocols, MPP. The migrants kept in MPP are sent back to Mexico as they await their hearings in the U.S. for asylum. DHS has reported that many of the migrants do not have an attorney or legal consultant present for their hearings. In late 2016, the Anglophone crisis began in Cameroon. Cameroonian Anglophones began to protest and riot against the government, resulting in ongoing conflict, making living conditions in Cameroon unsafe. Due to the conflict, many Cameroonians fear for their lives and well-being. The requirements for TPS designation include ongoing armed conflict, an environmental disaster, an epidemic or other extraordinary and temporary conditions. TPS status is humanitarian relief given to individuals currently in the U.S. who are unable to return to their own countries due to one of the TPS requirements. There have been numerous attempts by advocates and elected officials demanding the Biden administration designate TPS for Cameroonians.
Friends, show us some love and smash the like button. It doesn't cost you anything. If you have an immigration problem or need a second opinion because you cannot get a hold of your own lawyer, schedule a meeting with our team. Share information with our CARES team and they will help you get scheduled with our legal team. Now here's a secret code to unlock the free 15 minutes.